I'm delighted to introduce Aysha Ahmad onto the channel. Aysha's a barrister from 42 Bedford Row and specialises in employment and discrimination law. Aysha's going to talk about social media sins and what you need to be aware of. Thank you very much for joining me, Aysha.
Thank you, Matt, for inviting me to speak on this very exciting new area in employment law. It's a pleasure to be here. So I'm going to talk to you about the 7 deadly sins that you can commit in the social media context. The very first sin, the cardinal sin, if I may use that expression, is not having a clear social media policy. Your policies as employers need to be clear. They need to explain by way of examples what is an appropriate use of social media. They need to explain very clearly to employees what is covered. For example, which devices are covered, which hours are covered, which sites are covered. They need to set out clearly that there's a zero tolerance policy that you will apply to discriminatory and offensive posts. And they need to explain very clearly the link between dismissal and disciplinary sanctions and misuse of social media or breaches of your policy. And your policy needs to tie in with other policies like discrimination, equality and diversity, and your disciplinary policy. So an example of having a clear policy is a case where an Apple employee posted derogatory and very negative comments about Apple products on social media. It was actually a private Facebook, a Facebook post with private settings. However, the Apple social media policy made it very, very clear that they were not going to tolerate any negative comments about their products. And so the employees' misconduct was and findings were upheld by the tribunal, and Apple was successful in maintaining their position. Now, the second deadly sin that can be committed in the social media context is the assumption that what's personal will be protected. Now, personal can apply to a number of different areas: a personal device, a post made in personal time, so not during working hours, and in a personal space, so outside of the workplace. However, it's important for you to realize, if you are engaging with social media, that you can be fairly dismissed for posting about work in a derogatory manner, about your colleagues, about clients of your employer, or about your employer's products, even on personal devices, within your personal time, and outside of working hours. So your posts on social media will be scrutinized for content and context, and they will then be held up against the social media and disciplinary policies. So don't make assumptions that the personal is protected. The third deadly sin when it comes to social media is thinking that banter is an excuse. It isn't. So what might be funny in the context of jokey exchanges on a Friday night down the pub, where you say you're letting off steam, you work in a high pressured environment, you're out with your workmates, nobody was offended, it was all lighthearted, is unfortunately going to look very different in the cold light of day when the tribunal is faced with somebody who was offended and somebody who did think it was racist or sexist or homophobic or misogynistic. And unfortunately, you have a written transcript that is evidence of exactly what was said. And in that context, banter takes on an entirely different context, and banter is no longer an excuse. There will also be an explanation of what the content of your posts were to the judge. So if you think that the use of initials or the use of codes for other fellow colleagues won't be deciphered, they will. So I've dealt with cases where references are made to female colleagues with nicknames. Those nicknames will be explained to the judge. If they are graded, or often there are posts where women are ranked and there are different systems used for doing this, those will all be unpicked. And then there will be a judgment with findings of fact. Those findings of fact will then make their way onto a government website for all to see. So what started off as banter will end up in a judgment available to the public for your friends, your family, and crucially for future employers to be able to look up just by Googling your name. So it's important to be alive to that. The fourth social media sin is the assumption that the right to privacy, the Article 8 right under the European Convention of Human Rights, is an absolute right. It is not. It is qualified. And it's qualified if the interference is in accordance with law and necessary in a democratic society and for the protection of rights and freedom of others. So what the court will do is undertake a balancing exercise. They will try to determine whether the intrusion was a proportionate means of achieving a legitimate aim. Now, quite often in the context of social media, the legitimate aim that the employer will point to is that they would like a diverse workforce. They would like a workplace that upholds principles of equality and non-discrimination, a workplace that is free from sexual harassment. So those are legitimate aims which the employer will be arguing in front of the court warrant interference with your right to privacy. But it's important that the court does actually carry out that balancing exercise, and it's important that the employer can justify the intrusion into the employee's rights. So, for example, the Article 8 right covers privacy in correspondence. So there's a famous case which made the news, so a lot of people will be aware of it. It was called Barbulescu v. Romania. And in that case, the use of Yahoo Messenger was brought up, and an employee was emailing his fiancée, and the employer scrutinized those emails, and he complained about the scrutiny as being a breach of his privacy. Now, initially, the ECHR thought that the employer was absolutely entitled to scrutinize because they wanted to know what he was doing on their time and whether or not he was working. However, the court has held that, in fact, the Romanian court didn't balance properly whether or not there could be a less intrusive way of achieving the same aim. So it's a balancing exercise, in effect. It's not an absolute right. Now, the fifth social media sin is an assumption about another right under the ECHR. This time it's the Article 10 right to freedom of expression, and assuming that that is unfettered. Now, employees think that, well, look, if I'm posting my personal views, I'm entitled to do it, and I'm entitled to do it on various social media platforms. Be careful, because if your personal views are discriminatory or offensive, even if they are posted on your personal accounts and not in working hours, if they impact your your employer, and if they could possibly bring your employer into disrepute, then you will be held accountable and investigated and potentially disciplined. The degree of what the interference with that right to express yourself is will depend on the facts of each case. So, for example, to give you two different scenarios, there was a housing officer who posted on his private Facebook settings that he thought the right to have civil ceremonies to celebrate civil partnerships was an equality too far. Now, he was disciplined because the housing trust said they didn't want that sort of intolerant material associated with them. The court thought that it was a mild expression of his views, and that most right-minded individuals, reasonable individuals reading that wouldn't really think that that was a view shared by his employer, and it didn't really represent them, and it was unlikely to cause reputational damage. So in that case, the employee's freedom of expression to some extent was upheld, and he wasn't considered to have been fairly disciplined. However, there's been the case of Miss Omooba, who is an actress who is a Christian actress, and she posted her views about the fact that she didn't think people were born homosexual, and she went on to elaborate other views about homosexuality. Now, the theatre that were employing her had to let her go, and she sued them. She sued them for discrimination on the grounds of her religious beliefs. But the tribunal did not uphold her claim, and that's because the theatre were able to show that there was a detrimental impact on their reputation, on the reputation of their directors. There was adverse publicity, and the theatre's good standing was called into question with the public perception of the lead actress posting material like this. Now, what's interesting is that the post was years before, but it was shared by a friend of hers, and then it got reshared and retweeted, and that is what caused the reputational problems for the theatre. But she was unsuccessful. So there will always be a varying degree of interference, and the courts will balance that interference carefully. The sixth social media sin is that employees assume sometimes it's okay to cyberloaf. It's not okay to cyberloaf. And by cyberloafing, I mean wasting time at work that is meant to be productive on social media sites. And it comes as news to employees often that employers are absolutely entitled to monitor, scrutinize, and potentially discipline employees for misuse of their time whilst at work on these sites. So some employers go as far as to ban the use of such sites during working hours. Others set out very clearly in their social media policies that the use, unless it's work related, and you're engaging as a brand ambassador and liaising with clients on social media, you're not allowed to do it. What is also interesting is that quite often it's innocent monitoring of social media use that will throw up more serious breaches of social media policies. So being restrained in the use of personal use of social media during working hours is probably far better. The seventh and final deadly sin in the social media context is the assumption that you are safe because of encryption. You're safe if you are using private settings, or you are posting material on private groups. End-to-end encryption, to start with, is something that sites often advertise because they are protecting individuals from government hacking, your employer is unlikely to hack you in order to decide whether or not you have breached their social media policy. By and large, the way in which social media misuse comes to light is somebody on your WhatsApp group. So somebody who is a member of that group will get offended, will get scared, and will complain about the content. Or as is often the case where it's a device that is a work device, you hand it in. It's then going to be wiped for use by another employee, and inadvertently your inappropriate use of social media is discovered. Quite often, the device could be requested as part of an investigation into, say, an allegation of sexual harassment at work. And again, material will be discovered. The use of private settings doesn't save you from misuse. And this is because somebody who has access to your posts can simply reshare. People can take screenshots and reshare. People can go to your employer and tell them. It's quite often friends who will inform employers that you are tweeting or posting inappropriate content. What's also important to remember is that this will form evidence in any future case. So the posts that were made, even if they're taken down relatively quickly, how many hours they were up for, how many views those posts had, whether they were retweeted and reshared, will all be a matter of evidence. People will take screenshots, particularly if they have an in-house HR team, an in-house legal team. What has to happen vis-a-vis the collection of evidence for a social media case will be known to these individuals, and they will have collected this evidence. So encryption and private settings are really a bit of a red herring, and they won't save you. So those are the 7 deadly social media sins that you can commit in the context of social media and your workplace. So my advice is think very carefully before you type, tweet, post, or share.
Aysha, thank you very much. That's great. People really need to be careful when using social media. And I'm sure people will find your video really helpful. So thank you very much for coming on the channel. Much appreciated.
Matt, thank you very much for inviting me. And it's been a pleasure. And I hope it was helpful, a helpful synopsis of the landscape.
That's great, Aysha. Thank you. For more information, do browse this channel and visit my website. Remember that this video is for guidance only and should not be relied upon for specific advice. Also, the law can change. And finally, please subscribe to my channel for updates.